Getting married means blending your lives, your dreams, and often your finances. Love and partnership are at the center of marriage, but the way you and your spouse handle money and property together has long-term consequences, especially when it comes to your estate planning. A lot of couples think estate planning is something you do later in life, after you've bought a house or you've had a child. But in reality, the foundation is laid much earlier, with how you and your spouse decide to characterize and manage your property from the very beginning. In this video, I'll explain why these early decisions matter, how the law may treat your assets differently than you might expect, and what steps newlyweds can take to protect themselves and their estate. In states like California and other states that have community property laws, the way that you label your assets, whether separate property, community property, or some mix of the two, have real consequences. It affects your ownership rights during marriage, what happens when you divorce, and how your estate is distributed when one of you passes away. And if you don't make intentional choices, state law will step in and make these choices for you. For example, in California, income earned during marriage is generally considered to be community property, regardless of which spouse earned it. This means that each spouse automatically has a 1/2 interest in it. And here's a surprise for many newlyweds. Just because an asset, like a bank account or a house, is titled in the name of only one spouse, it doesn't automatically make it separate property. Title and ownership aren't always the same thing. If you and your spouse want to keep assets acquired during marriage as separate property, including your salaries, you'll need to create a premarital or a postmarital agreement. Without that kind of planning, couples often realize far too late that their assumptions about what's mine and what's ours don't match the law. Let me give you an example. Suppose Jordan inherits a house from his parents before marriage. At first, the house is clearly Jordan's separate property. But after marrying Sam, the couple uses their community earnings, their salaries, to pay the mortgage and to fund improvements. Over time, the law may not see the house as purely Jordan's separate property anymore. The community may have acquired an interest in it simply because community funds helped build equity. Without careful record keeping or agreements, situations like this can complicate divorce and estate planning, and often create results that neither spouse expected. These conversations about property, money, and ownership aren't always easy, but they're far easier if you have them early on in your relationship, before misunderstandings or disputes can arise. When you and your spouse are both on the same page from the start, it creates trust, clarity, and a strong foundation for your future together. There are a couple of tools that can help. First, a premarital or a postmarital agreement. These documents aren't just for celebrities or for the ultra-wealthy. They're a way to set clear expectations about what's community property, what's separate property, and how you want things handled if life takes an unexpected turn. For many couples, having these conversations in writing actually reduces conflict and can strengthen the relationship. Second, detailed record keeping. If one of you has separate assets, like property acquired before marriage or property inherited during marriage, keeping careful records about where the money comes from and how it's used is essential. Even something as simple as a dedicated account for separate assets can go a long way in preserving their status. By starting these conversations early, you avoid the he said, she said later on, and you make sure that your estate plan accurately reflects your wishes and not just the default state law. When it comes to managing property as newlyweds, a few simple habits can make a big difference. Here are some important do's. Do keep inherited or gifted assets in separate accounts or a separate trust. This is the cleanest way to preserve their status as separate property. If you put them into a joint account, you may unintentionally convert them into community property. Do try to avoid commingling. For example, if you use community earnings to pay a mortgage or fund improvements on a separate property home, the community may gain an interest in that property. If commingling is unavoidable, keep careful records to show what funds were used for what. Do put agreements in writing, whether it's a premarital agreement or a postmarital agreement. Having your intentions documented creates clarity and avoids confusion and conflict later on. And here are some don'ts to keep in mind. Don't just add your spouse to the title of a community asset without seeking advice. For example, if you inherit a house and you add your spouse to the deed, you may have given away half that property interest, sometimes without even realizing it. Always talk to a family law or estate planning attorney beforehand. Don't assume that title alone determines ownership. Just because a bank account or a house is in one spouse's name does not automatically make it separate property. The law looks at where the funds came from and how they were used. Don't commingle separate and community assets without careful consideration. Once funds are mixed, it's very difficult to untangle them later on. And courts don't always sort things out the way that you expect them to. Don't wait until later in life to talk about property characterization. The earlier you decide how to handle things, the easier it's going to be to maintain consistency. And don't forget that earnings acquired during marriage are considered community property. Even if only one spouse is working, both spouses have an ownership interest. Keeping these do's and don'ts in mind can save couples from unintentional mistakes, which can complicate both divorce and estate planning. The way you and your spouse decide to manage finances today shapes not only your financial future, but your estate plan tomorrow. By being proactive, talking openly about property management, documenting your decisions, and keeping your estate plan up to date, you can give each other peace of mind. And you ensure that no matter what happens, your loved ones are taken care of in the way in which you intend. If you're newly married, now's the perfect time to get these conversations started and put the right documents in place. I offer consultations to newlyweds to help them build a strong foundation and an estate plan that reflects their life together. Reach out today and let's make sure that your estate plan protects you legally as well as emotionally.